Russell Halverson, we have a warrant. Step away from the desk.
Of course. It's always the guy on the ground who takes the fall, not the system that built this.
Once is a mistake, twice is suspicious. Russell Halverson did this 47 times across 4 years and kept a notebook with every name, every dollar, and whether they'd paid.
That's the 47 people you extorted. We have the recordings.
He would not be the one filing the violation report this time. 47 probationers across 4 years and 3 months. $381,400 in cash, scaled to a man's failed drug screen, his missed curfew, his pending early termination. 41 minutes of audio recorded from the passenger seat of a Chevy Malibu in a strip mall lot on State Road 9. The man in the body cam is Russell Halverson, a senior probation officer in Irongate, Indiana. A federal judge would deny him bond before lunch. Quick question for you. How does someone keep a side ledger like this for 4 years without a single co-worker noticing? Drop your theory in the comments. And if you're new here, subscribe. We cover cases like this every single week, and the details only get worse from here. Russell Thomas Halverson was born in October 1977 in Muncie, Indiana, the second of 3 sons in a family that lived 2 blocks from a Borg-Warner manufacturing plant. His father worked as a tool and die operator on the second shift for 31 years. His mother managed the cafeteria at Northside Elementary School. The family attended a Methodist church in name only, ate dinner at 5:15 every weeknight, and considered a stable paycheck the highest form of moral achievement a person could aspire to. By the time Russell graduated from Muncie Central High School in 1996, the Borg-Warner plant was already losing shifts. His older brother enlisted in the Army. His younger brother went to work at a body shop on the south side of town. Russell did neither. He enrolled at Ball State University on a partial academic scholarship, took a part-time job stocking inventory at the Marsh Supermarket on McGalliard Road, and chose criminal justice as his major after a sophomore year ride-along with a Delaware County Sheriff's deputy who let him hold the radio. He graduated in May 2000 with a bachelor's degree in criminal justice and no immediate prospects. The Indiana Department of Correction was hiring. He applied to the Corrections Officer program in February 2001, passed the physical, and reported to the training academy in Indianapolis that April. His academy instructors described him in their final evaluations as punctual, even-tempered, and slow to escalate. He was assigned to a state correctional facility in central Indiana and spent the next 7 years working the housing units. The corrections years shaped him. He learned the gestures of authority and the language of confinement. He learned which officers got hurt and which ones did not, and the difference was usually a matter of when a man chose to look up and when he chose to look down. He learned that the inmates with the least to lose were the most predictable, and that the ones with families on the outside were the easiest to manage. He filed his disciplinary reports neatly. He testified at hearings without theatrics. He took the overtime he was offered, banked it, and used the first significant raise to put a down payment on a used Ford pickup. In 2009, he applied for a senior corrections specialist track, was passed over twice, and decided to leave. A former academy classmate had moved into adult probation work in Irongate County and told him the hours were better, the work was quieter, and the discretion afforded to an officer was substantial. Russell completed his master's degree in criminal justice through an online program at Indiana State University while still working correction shifts. He started with the Irongate County Adult Probation Department in March 2010 at a starting salary of $41,200 a year. His first supervisor wrote in his 6-month evaluation that he was well suited to the work, professional in his demeanor, and showed strong judgment in violation assessment. His second evaluation, in 2012, used the phrase operates effectively with limited oversight. That phrase would appear in his personnel file 3 more times across the next decade, in identical wording, copied from one annual review to the next, because no one in the supervisory chain had any reason to rewrite it. By 2016, he was a senior probation officer, carrying one of the heaviest caseloads in the department. By 2020, he was earning $63,800 a year supervising between 90 and 110 adults at any given time, and had not received a corrective performance note in 8 years. He had married a woman named Cheryl in 2005, a dental hygienist who worked at a practice on the east side of Irongate. They bought a 1-story brick house on a quarter-acre lot off Maple Hill Road in 2007 for $142,000. They never had children. They went to the Methodist Church on Easter and Christmas. They paid down their mortgage on schedule. The neighbors described them later, when the federal agents knocked on doors up and down the block, as quiet, polite, and entirely unmemorable. Probation is the part of the American criminal justice system the public almost never sees. The arrest is on television. The sentencing is on the courthouse steps. The probation officer's office is on the 4th floor of a county building behind a metal detector, and what happens inside that office happens between 2 people, one of whom has a job and the other of whom has a problem. In Indiana, a sentencing judge who imposes a term of probation hands the actual supervision of that sentence to a county adult probation department. The probation officer becomes, for the duration of the term, the single most consequential person in the probationer's life. The officer sets the check-in schedule. The officer administers or orders the drug screens. The officer decides whether a missed curfew is a violation or a warning, whether a positive urine is a relapse or a setback, whether a new arrest constitutes a violation petition or a wait and see. The officer writes the reports the sentencing court relies on. The officer recommends early termination or denies it. The officer, by signing one piece of paper, can return a probationer to custody for the remainder of the underlying sentence. The probationer has the right to a hearing before that happens. The probationer also has, on average, a court-appointed attorney with 200 other open cases, a criminal record that predisposes the judge to credit the officer's account, and a life held together by appointments that cannot survive a week in county jail. The asymmetry is not subtle. It is the predicate of the entire relationship. The Irongate County Adult Probation Department occupied the 4th floor of the County Services Building on Main Street, behind a single elevator and a single stairwell, both of which fed into a beige hallway with a metal detector and a sign-in clipboard. There were 11 officers on the floor. There were 2 clerical staff. There was a supervisor who had held the position since 2014 and who had, by department records, never once sat in on a probationer interview that was not a formal violation hearing. Caseload audits were conducted quarterly. They consisted of a spreadsheet pulled from the case management system, showing the number of cases per officer, the number of violation petitions filed, and the number of early terminations recommended. The supervisor reviewed the numbers, signed the audit, and filed it in a drawer. No one read the underlying case files. No one cross-checked the violations that officers reported against the violations actually documented in the drug screen records, the GPS data, the curfew check logs, or the police contact database. The system trusted the officers because the system did not have time not to. Russell Halverson, according to his personnel file, operated effectively with limited oversight. That phrase appeared in his record 3 more times after the first. The first payment was $800 in cash, taken from a man identified in the federal indictment only by the initials DMDM, was 31 years old, on probation for a Class 6 felony drug possession, 11 months into a 2-year supervised term. He had failed a urinalysis on the morning of March 9, 2020, screening positive for methamphetamine. The failed screen, properly reported, would have triggered a violation petition, a hearing, and a likely return to custody for the remainder of his sentence. He had a 6-year-old daughter who lived with his sister, a job at a parts warehouse in Anderson, and a court-mandated treatment program he had attended every single week for almost a year. Russell Halverson pulled up the screen result on his desktop computer that afternoon. He called DM back to the office. He closed the door, sat down across from him, and asked, with no theater and no preamble, what the failed screen was worth to him. That is what DM would later tell federal investigators. That is what 46 other probationers would, over the following 4 years, tell similar versions of. The mechanism was simple and almost entirely deniable. Halverson identified the probationers on his caseload who had committed technical violations. He had the discretion to report or not report. Failed drug screens, missed curfews, documented contact with prohibited persons, new misdemeanor arrests that had not yet resulted in conviction. He approached them privately, in the office or in his vehicle in the parking lot of the county services building, and he offered them an arrangement. $200 for a missed curfew, $300 for a positive screen, $500 for a more serious technical violation, $800 to $1,200 for 2 or 3 stacked violations in a single review period, $5,000 in a single payment to file an early termination recommendation or to write a favorable progress report ahead of a sentence modification hearing. The probationers paid. Some scraped the money together from family. Some sold things. One sold the catalytic converter off his own car. One borrowed from a cousin she lived with and told the cousin the money was for an emergency dental procedure. They paid because the alternative was custody, and custody meant the loss of the job, the apartment, the visitation, the slow 18-month climb back from the conviction that had defined their lives. Halverson collected the payments in cash. He preferred parking lots. The county services building lot in the evening, after the office closed and the clerical staff had gone home. A strip mall lot on State Road 9, 2 miles east of the office, near a Family Dollar and a tax preparation storefront. On one occasion, documented later by a fast food restaurant's interior surveillance camera, he sat across from a probationer in a booth at a Taco Bell on East Lincoln Street during the probationer's 30-minute lunch hour and accepted a folded envelope across the table while drinking a large Mountain Dew. He kept a notebook. It was a green hardcover composition book, the kind sold in 3-packs at the back-to-school sale at the Walmart on South Memorial. He kept it in the bottom drawer of the desk in the spare bedroom of his house, inside a manila folder labeled Refinance. Inside the notebook were the initials of every probationer who had paid him, the date of the underlying violation, the amount agreed to, the amount actually received, and a column on the far right marked Paid or OED. The escalation was steady. The first year, from March 2020 to March 2021, the documented payments totaled approximately $41,000. The second year, $68,000. The third year, $94,000. The fourth year, by the time the recordings would eventually be made, he was on pace to clear $150,000 in unreported cash income from a job that paid him $63,800 a year before taxes. He never spent extravagantly. He made deposits to his wife's separate banking account in amounts under $10,000, 3 or 4 times a month, at 4 different branches of 2 different banks. He paid down the principal on the Maple Hill Road mortgage. He replaced the roof. He bought a 16-foot tracker bass boat. He drove a 2014 F-150 that he kept washed. He had, in the language of his own personnel file, operated effectively with limited oversight. His name was James Edward Croft, and he was 11 days from the end of his probation term. Croft was 38 years old. He had pleaded guilty in 2021 to a Class 5 felony theft for stripping copper wiring from a vacant warehouse on the north side of Irongate. He had been sentenced to 3 years total, with 2 years suspended. He had served the 11 non-suspended months in the county jail, and the remaining 2 years on probation under Russell Halverson's supervision. He had paid Halverson 3 times across those 2 years. $200 for a missed check-in in the spring of 2022, $400 for a positive screen for marijuana in the fall of 2022, $600 for a documented contact with a co-defendant from the original case in early 2023. He had paid in cash in the county services building parking lot in envelopes Halverson had specified should be plain white with no markings on them. In June 2024, 11 days before his probation was scheduled to expire, Halverson called him into the office and told him there was a problem. A curfew check on the night of May 28th had documented him as not present at his registered address. The violation, properly reported, would trigger a petition, a hearing, and a possible revocation of the entire 2-year suspended portion of his sentence. 1 year, possibly more, back in state custody. Halverson sat across from him at the desk on the 4th floor. He said it would cost $1,200 to make the curfew violation disappear. He said it the way he had said it 46 times before, with no embarrassment and no apology, in the same flat administrative voice he used to explain check-in schedules. Croft drove home. He sat in the driveway of the apartment he shared with his sister for 40 minutes without getting out of the car. He had 11 days left on his term. He had a job interview at a logistics warehouse the following Monday. He had, on paper, a path forward to the rest of his life. And he had, at this point, already paid Russell Halverson $1,200 over 2 years to stay on that path. He went inside. He opened his laptop on the kitchen counter. He searched for the Indiana State Police Public Corruption tip line. He called the number on a Wednesday afternoon. He spoke for 41 minutes to a detective in the Internal Investigations section. He gave the detective the dates. He gave the detective the amounts. He gave the detective the locations. He gave the detective the first names of 3 other probationers he was certain had paid as well. The detective asked him if he would be willing to wear a recording device on his person and document a future payment. Croft said yes. He said it on his 8th day of supervision remaining. He said it knowing that if Halverson decided to file the violation petition at any point in the next 8 days, before the recording could be made, he would be returned to custody for the remainder of his suspended sentence, and the recording would never matter. He said it anyway. He said he had nothing left to lose, and he was tired. We're heading into the investigation now. If you've made it this far, you already know this channel doesn't soften these cases. Subscribe if you want to see exactly how 41 minutes of audio closed the door on Halverson's career. We do this every single week. The first recording was made on June 14th, 2024, in the parking lot of the strip mall on State Road 9. Detective Sergeant Lana Whitfield of the Indiana State Police met James Croft at a Cracker Barrel off Interstate 69 the night before. She fitted him with a recording device the size of a car key fob. She gave him a written script of suggested conversational topics, confirmed the curfew violation date, confirmed the amount, confirmed that the payment would result in no violation petition being filed, confirm any reference to previous arrangements, if it came up naturally. Croft drove the Chevy Malibu his sister had co-signed for to the State Road 9 lot at 3:12 in the afternoon. Halverson arrived 8 minutes later in his F-150 and parked 1 space over. He got into the passenger seat of the Malibu because that was the established pattern Croft had described to investigators. The recording captured the door opening, the engine fan, the muted sound of a country station playing 3 blocks away through someone else's open window. The conversation lasted 19 minutes. Halverson named the amount. He acknowledged the specific curfew violation by date. He explained the timeline of when the violation would be closed in the case management system if no petition was filed. He took the envelope. He counted the bills with his thumb in the passenger seat while still talking. He said the line that would, 3 weeks later, be played in open court at his detention hearing. We're square through the end of the month. The second recording was made 8 days later, in the same lot, with the same device. It was 22 minutes long. Halverson, on that recording, suggested an additional arrangement. He said he had reviewed Croft's file and identified another marginal flag in the screening records from April that he could choose to write up or not. He offered to handle that one as well for an additional $400, payable the following week. That was the end of the operation. Federal investigators executed a search warrant on Halverson's home and vehicle on the morning of July 22, 2024. They recovered $46,000 in banded cash inside a green canvas duffel bag in the garage, tucked behind a stack of plastic storage tubs labeled Christmas. They recovered a personal cell phone, registered in his wife's name, but used exclusively by Halverson, containing text exchanges with 11 different probationers about payment amounts and meeting locations. They recovered the green composition notebook from the bottom drawer of the desk in the spare bedroom, inside the manila folder labeled Refinance. The notebook listed 47 sets of initials. It listed dollar amounts ranging from $150 to $14,000. It listed dates spanning 4 years and 3 months. It listed, in Russell Halverson's own handwriting, paid and owed. Forensic accountants reviewed the banking records of Halverson and his wife. They identified approximately $290,000 in cash deposits to her separate account, made in amounts strategically under the $10,000 federal currency transaction reporting threshold between April 2020 and June 2024. The deposits had been made at 4 different branches of 2 different banks. They had been made at irregular intervals. They had not been declared on any joint tax filing. A statistical review of Halverson's case management records was conducted by an analyst with the Indiana Office of Court Services. Of the 47 probationers whose initials appeared in the notebook, every single one had at least one documented violation event in the underlying records that had subsequently been closed in the case management system without a corresponding violation petition. The pattern was statistically inconsistent with the office baseline by a factor that the analyst's report described as not occurring by chance. 3 of those probationers had already filed post-conviction petitions in state court before the indictment was even handed down. They had filed them on the basis of nothing more than an instinct that the system was rotten. They had been right. Federal agents and Indiana State Police investigators arrived at the Maple Hill Roadhouse at 6:42 in the morning on July 22, 2024. Halverson answered the door in a gray t-shirt and dark gray sweatpants. He had not yet put on his glasses. The lead agent identified himself, presented the warrant, and instructed Halverson to step out onto the porch and place his hands on the railing. The body cam recording captured what followed. "Mr. Halverson, we have a federal warrant for your arrest. We also have a search warrant for the residence. We need you to step out and put your hands behind your back. What is this about?" "Sir, you know what this is about. I want a lawyer. That is your right. We are placing you under arrest for federal extortion under color of official right and related charges. Please turn around. 47 years. You're going to do this on my porch at 6 in the morning. Sir, turn around." He turned. He put his hands behind his back. He did not look at his wife, who was standing in the hallway of the house in a beige robe, holding a cordless phone she had picked up off the cradle and not dialed. He did not speak again on the way to the federal vehicle. The neighbors who later spoke to local reporters said Russell Halverson was the quietest man on the block. He took the trash cans out on Sunday nights. He nodded when you passed him in the driveway. He had, on the morning of his arrest, less than 4 hours earlier, taken the Beagle out for its usual walk to the end of the street and back, the same loop he had walked every morning for almost a decade. He invoked counsel within 90 seconds of the encounter beginning. He did not make a statement. He did not deny anything. He did not justify anything. He did not ask, the way many subjects ask, what the agents had on him or what they thought he had done. He went silent on the porch, and he stayed silent in the back of the federal vehicle, and he stayed silent through processing, and he stayed silent through his first appearance. The silence was the most professional thing he did in the whole case. The indictment was filed on July 25, 2024, in the United States District Court for the Northern District of Indiana. 47 counts of Hobbs Act extortion under color of official right, under 18 U.S.C., Parf 1951. 1 count of money laundering, under 18 U.S.C., Parf 1956. 1 count of deprivation of rights under color of law, under 18 U.S.C., Paragraph 242, relating to the 18-month coercion of a female probationer, identified by the initials T.S., who had paid Halverson a documented total of $14,000 over a period during which she had also, the indictment alleged, been compelled into a series of physical encounters under the direct threat of violation reporting. The state of Indiana filed parallel charges of official misconduct, bribery, and sexual misconduct with a person in custody. The detention hearing was held on July 26th. The courtroom was nearly full. 3 probationer victims were present in the gallery. Halverson's defense attorney, Russell C. Trent, of an Indianapolis criminal defense firm, argued for release on conditions. He cited the 8 years of service with the probation department. He cited the master's degree. He cited the absence of any prior criminal history. He cited the 19-year marriage. He cited the modest brick home. He cited the lack of a passport. He cited the absence of any history of violence. He spoke for almost 20 minutes. The government called Detective Sergeant Whitfield. She testified for 22 minutes. She described the recordings. She described the notebook. She described the cash recovered from the garage. She described the structured deposits and the statistical analysis of the case files. She testified that the investigation had already identified at least 3 probationers whose underlying violations had been the subject of state post-conviction petitions, and that the cooperating witnesses in the federal case were probationers whose physical safety the Indiana State Police considered to be at active risk. The Assistant United States Attorney then asked the court for permission to play 4 minutes of audio. She played the section where Halverson named the amount. She played the section where he accepted the envelope. She played the section where he confirmed the specific curfew violation he was agreeing to suppress. And she played the section where Russell Halverson, in his own voice, told James Croft, "We're square through the end of the month." The judge listened, with her hands folded on the bench. When the audio ended, she removed her reading glasses and addressed the courtroom directly. The defendant in this case held a position of singular trust over individuals whose liberty depended on his judgment, she said. The evidence before the court suggests that he did not merely abuse that trust. He commodified it. He turned the discretion vested in him by the people of the state of Indiana into a private revenue stream operated out of the parking lot of a county building. The threat of retaliation against cooperating witnesses is, in the court's view, both credible and severe. The motion for release on conditions is denied. She denied bond before lunch. Russell Halverson was remanded to the custody of the United States Marshals Service and transferred to a federal detention facility in northern Indiana to await trial. He pleaded not guilty at arraignment. The case is pending. 3 of his probationer victims have, as of this filing, been granted post-conviction relief on the underlying violations they had paid to suppress, and additional petitions are pending in state court. He was terminated from the Irongate County Adult Probation Department in August 2024, with the termination dated retroactively to the morning of his arrest. His pension contributions were frozen pending the outcome of the federal case. His wife filed for legal separation in October. The Maple Hill Roadhouse went on the market in January. The green composition notebook, the one with the manila folder labeled Refinance, is now Exhibit 14 in the case against him. Russell Halverson has not been seen outside of federal custody since the morning of July 22, 2024. This case was disturbing, but the case on your screen right now is somehow worse. Click it.